Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This week, we've got 10 cases, including a blockbuster from the Attorney General on the categorical approach. Think Jaws, Titanic, the opening sequence of Star Wars 4 when Darth Vader blows up the planet Alderaan, that kind of blockbuster. It's been a crazy week as I move out of my apartment and begin a cross-country relocation to San Diego, where I'll be opening up a branch of the Kurzban law firm. But the immigration review must go on. While I'm on the road for the next 2 weeks, my incredibly talented co-pilot, co-podcast collaborator, and fiancé, Kim A. Cruz, will be taking the reins of the show. Kim's a former EOIR attorney advisor herself, and she's a soon-to-be federal law clerk, and she's going to kick butt. But this week, you must still settle for me. So, on to the first case. So the Attorney General issued a big one this week. Matter of Reyes, published on July 30th, 2020. By my count, this is now the 11th precedential immigration decision issued by a Trump Attorney General in the last 3.5 years since January 2017. And there are another half dozen or so decisions that the Attorney General has referred to himself that he will presumably decide before November. By contrast, I believe that all of President Obama's Attorney Generals issued like 6 decisions in 8 years, none of which, to my recollection, were particularly consequential. This case is about how the Attorney General wants immigration judges to apply the categorical approach. In a nutshell, the AG said that if all means of committing a crime match the definition of some aggravated felony, then the non-citizen is removable, even if the conviction doesn't match the definition of a single, specific aggravated felony. If that sounds weird and complicated, it's because it is, and it's never been the law. Ever. Anywhere. Here's what's going on. As we know, a non-citizen is removable and barred from most forms of relief if his conviction constitutes an aggravated felony. Depending on how you're counting, there are about 30 or so aggravated felony definitions at Section 101A43 of the Immigration and Nationality Act. To determine whether a state or federal conviction is an aggravated felony under immigration law, courts apply the categorical approach, which requires a comparison of the elements of the non-citizen's criminal offense with the elements of an aggravated felony. If the non-citizen's criminal offense criminalizes more conduct than the aggravated felony definition, the criminal offense is not an aggravated felony. Here's an example. Section 101A43G defines an aggravated felony theft offense, which requires an intent to steal. If, say, a Florida statute criminalizes stealing a car and also criminalizes simply borrowing a car and accidentally failing to return it, the Florida theft offense would likely not be a theft offense aggravated felony, because it can be committed without an intent to steal. This is similar to what happened in this case. Ms. Reyes, a lawful permanent resident, or LPR, was convicted under New York Penal Law 155.401 for second-degree grand larceny. DHS charged Ms. Reyes as removable for a theft offense aggravated felony, and additionally, under INA 101A43MI, which defines a fraud-type aggravated felony, where there is a loss to the victim that exceeds $10,000. Under BIA and circuit precedent, the difference between a theft offense at 101A43G and a fraud offense at 101A43MI is really whether or not the stealing is accomplished with the consent of the victim. If the consent of the victim is absent, say like stealing a car at gunpoint, the crime matches the federal definition of a theft-type aggravated felony, 101A43G. By contrast, if the crime does require consent, say securities fraud where Bernie Madoff convinces investors to give him money and then steals the money, you have a fraud-type aggravated felony, 101A43M. But the two don't necessarily overlap. When you take without consent, you've committed theft, and when you take with consent, you've committed a fraud. So now, applying those concepts to the issue at hand. New York Penal Law 155.41 can be committed through straight theft or through theft by fraud with the consent of the victim. Consequently, the New York offense is overbroad when compared with both Section G, which requires theft without consent, and Section M, which requires theft with consent. Before the Attorney General's decision in this case, the only way the analysis would proceed any further is if the statute was divisible. This would require a showing that stealing with consent and stealing without consent are separate elements of the New York offense. That is, if a prosecutor had to prove at trial either that a defendant stole without the consent, or alternatively, by fraudulently obtaining consent, only then could a court use the modified categorical approach to review the conviction documents and determine whether the conviction matched a theft-type aggravated felony, or alternatively, a fraud-type aggravated felony. That's not the case with New York Penal Law 155.40. The stealing with consent and stealing without consent prongs of the crime are means, rather than separate elements of the offense, meaning that the statute is not divisible, and the conviction can never match the definition of any single aggravated felony. What then is an enterprising Attorney General to do? Well, he can change the law, which is what he did, and Attorney General Barr concedes he is changing the law. According to the Attorney General, all that matters in the criminal conviction analysis is that all means of committing the non-citizen's offense match the definition of some aggravated felony. In this case, some alternative means of the New York statute matched the theft-type aggravated felony at subsection G, and others matched the fraud-type aggravated felony at subsection M. So, the Attorney General reasoned, the conviction matches the aggravated felony definition, albeit not any specific one. And for that reason, Ms. Reyes is removable from the United States. So much to say on this case, and I've already said a lot, so I'll be as brief as possible. The categorical approach has been around for at least 3 decades, and it's not just applied in immigration cases. It also applies in the sentence enhancement context used in federal court to make criminal sentences longer for defendants who have committed multiple crimes. The circuits publish categorical approach cases in these areas of law every single week. I don't believe the categorical approach has ever really been applied by the circuit courts in this way. And this is important, because unlike some aspects of immigration law, the circuits owe no deference whatsoever to the BIA or the Attorney General's application of the categorical approach. Rather, the BIA and the Attorney General, and immigration judges for that matter, must defer to how the circuits apply the categorical approach. And I can almost guarantee you that every single circuit has published multiple cases that expressly do not apply the categorical approach in this manner. That means, so long as a practitioner can find a decision in your circuit that contradicts the Attorney General's decision, that the immigration judge in any given case cannot and should not follow the Attorney General's contrary decision in Reyes. To be fair, the Attorney General relies on approximately one 12-year-old circuit case that is kind of on point to support his analysis. I personally do not believe that matter of Reyes is long for this world. Finally, for what it's worth, at footnote 3, the Attorney General implies that even under his new approach, to be found removable for one conviction that matches multiple aggravated felonies, DHS must charge both aggravated felony provisions in the notice to appear. so don't let DHS spring this new theory on you at your individual hearings, practitioners. DHS must amend the NTA, even for this approach to work. And that is matter of Reyes. Sticking with the categorical approach, we've got Orellana v. Barr, published by the Ninth Circuit on July 28, 2020. This case is about our old friend of the show, CIMTs, or as my mother Susan Gregg keeps telling me to specify, crimes involving moral turpitude. Mr. Orellana is an LPR who was convicted of 2 counts of criminal stalking under California Penal Code Section 646.9a. Because 2 CIMTs make an LPR removable, if criminal stalking is a CIMT, Mr. Orellana is removable. The Ninth Circuit held that the convictions are CIMTs, and here's why. To make this determination, the Ninth Circuit applied the usual categorical approach, and not Bill Barr's categorical approach. Recall, the Ninth Circuit's definition of a CIMT is one involving, quote, either fraud or base, vile, and depraved conduct that shocks the public conscience, end quote, and generally requires an evil intent. Criminal stalking in California requires that the defendant, quote, willfully, maliciously, and repeatedly follow or willfully and maliciously harass another person, and make a credible threat with the intent to place that person in reasonable fear for his or her safety or the safety of his or her immediate family, end quote. The Ninth Circuit held that this statute was similar to the statute reviewed in matter of Ajami, wherein the BIA held that a Michigan stalking conviction was a CIMT. The Ninth Circuit also applied the realistic probability approach correctly, and held that Mr. Orellana couldn't show that the presumptively turpitudinous California stalking statute was, as applied in practice, non-turpitudinous. Okay, fine. But an LPR is only removable for having been convicted of 2 CIMTs if the 2 CIMTs do not arise out of a single scheme of criminal conduct. The Ninth Circuit, however, held that Mr. Orellana's 2 counts of stalking did not arise out of a single scheme, because the stalkings occurred on different days, and indeed possibly different years. Not really sure what Mr. Orellana's counterargument was there. So, Mr. Orellana is removable and ineligible for relief. Here are 2 observations, not arising out of a single scheme. In a concurrence that was picked up on Twitter and Law 360, Judge Owens believes the entire CIMT analysis used in the circuits is, quote, dumb, 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 end quote. Only 2 more dumbs required to qualify as a Cisco song. It's dumb da dum dum dum. Finally, and returning to my mother. My mom's a nurse who's over 60 years old. Sorry, Mom. And she's going to work every week, decked out in a spacesuit to combat COVID-19. To my mom and all the other essential frontline workers, thank you, and keep fighting the good fight. And that is Orellana v. Barr. Wrapping up the categorical approach this week, we've got Johnson v. Barr, published by the 10th Circuit on July 31st, 2020. This case is about the divisibility of a controlled substance list. Mr. Johnson is an LPR from the Bahamas. He was convicted of possession of a controlled substance in violation of Colorado Revised Statutes 18-18-403.51 and 2A. The Ninth Circuit held that under the categorical approach, the Colorado statute is overbroad, and that the statute is not divisible with respect to the controlled substance at issue. Here's why. As we've discussed before, most state controlled substance lists cover more drugs than the federal controlled substance list. Here, Colorado criminalizes possession of a drug called morpholine, and the feds don't. For this reason, a non-citizen convicted of a possession offense in Colorado is only removable if, under the categorical approach, the controlled substance possessed is an element of the offense that the prosecution must prove. And then if, under the modified categorical approach, the conviction documents show that the non-citizen possessed a substance listed on the federal list. i.e., not morpholine. Here, the 10th Circuit held that the Colorado statute is not divisible for a few reasons. First, it noted that the Colorado statute lists 3 specific controlled substances, but then simply refers to Schedule 1 and Schedule 2 of Colorado's controlled substance lists, which contain dozens of controlled substances. So, the 10th Circuit reasoned, Colorado believes that those 3 specific substances listed in the statute are elements that must be proven. But if those 3 substances are not at issue, as was the case here, then a prosecutor need not prove any specific substance. The prosecution simply needs to prove that any given substance in one of Colorado's 2 schedules was possessed. Accordingly, all the controlled substances contained within Colorado's 2 controlled substance schedules are merely means, and not elements of a possession offense. The 10th Circuit further supported this finding by relying on state case law and jury instructions, and additionally noted that Colorado punishes possession of a controlled substance listed in Schedule 1 and 2 identically, while it punishes possession of a Schedule 3 substance more severely. This further indicates that the substances listed in Schedules 1 and 2 are merely means and not elements. So, even though Mr. Johnson actually possessed hydrocodone, a controlled substance listed in the federal list, Mr. Johnson is not removable for having been convicted of a controlled substance offense. Great case for the categorical approach, particularly in light of the AG's attempted rewrite of 3 decades worth of categorical approach case law. Here are my 2 observations. First, practitioners should read this case to craft their categorical approach arguments regarding drugs. This case is a well-written roadmap. And in that vein, the 5th Circuit applied the categorical approach as it's supposed to be applied. For example, the court did not take a peek at the conviction documents, because the divisibility question was decided by the statutory text, the jury instructions, and state case law. The 10th Circuit made clear that, quote, only if these sources fail to provide clear answers may we then look to Johnson's actual record of conviction, end quote. Whereas here, the answer is provided by these tools, there is no realistic probability test to apply, and there is no peeking allowed. And that is Johnson v. Barr. Switching gears, we've got Gao v. Barr, published by the 2nd Circuit on July 28, 2020. This case is about claims of religious persecution in China and credibility. Mr. Gao overstayed his temporary visa and applied for asylum in the United States, testifying that he feared harm in China because he's a Christian. He testified that he hosted Bible studies in his home to avoid Chinese authorities, but that in May 2009, police entered his home, accused him and the attendees of being in a cult, and beat and interrogated him at a police station. He was then incarcerated for a month. After he was released, he didn't practice Christianity for 4 years, and police came to check on him from time to time. Then he came to the U.S. He began attending a church again in New York, and the minister of the church testified in immigration court. The IJ found that Mr. Gao was not credible, citing 6 primary inconsistencies between the details provided in his asylum application and his in-court testimony. The IJ also held that his demeanor was not credible, as Mr. Gao could not testify well when asked questions beyond the 4 corners of his asylum application. The BIA affirmed. Before the 2nd Circuit, Mr. Gao, through counsel, argued only that he had explained all of the inconsistencies. The 2nd Circuit went through the inconsistencies one by one, which I will not subject my listeners to, and held that Mr. Gao could not show that the record compelled a contrary finding, particularly when the inconsistencies were taken as a whole. So, Mr. Gao lost his asylum case. Here are 3 observations. First, many of Mr. Gao's arguments failed because even if there were plausible explanations for his inconsistencies, The explanations were never made to the IJ. This highlights the importance of effective rehabilitation after cross-examination. To at a minimum, make your record for the appellate bodies. Next, the court considered the fact that Mr. Gao had testified falsely on one matter to allow the IJ to disbelieve all matters. This comes from the Latin phrase falsus in uno, falsus in omnibus, or false in one, false in all, a principle adopted in many circuits for asylum cases. I think practitioners can use this principle to our client's benefit and present instances from the non-citizen's life where he or she has been truthful, even if unrelated to the asylum claim, to argue the inverse, honest in one, honest in all. And finally, as the immigration attorney listeners know, religious persecution cases from China are very prevalent, particularly in New York and LA, and the Second Circuit has probably reviewed thousands of them. Some of the stories are made up, others are not, but I believe in practice, many judges look suspiciously on such claims. Witness preparation, including mock cross-examination, is key to make sure that the meritorious claims succeed. And that is Gao v. Barr. Demonstrating that one learns something new in immigration law every week, we have Sathanthrasa v. Attorney General of the United States, published by the Third Circuit on July 30th, 2020. This case concerns a weird regulatory interplay between withholding of removal and asylum. Mr. Sathanthrasa is from Sri Lanka and was granted withholding of removal by an IJ due to his fear of the Sri Lankan government and the Karuna Group, an offshoot of the Tamil Tigers. To quickly summarize, he and his family suffered a lot of harm and threats in the mid-2000s, but Mr. Sathanthrasa remained in Sri Lanka for another 7 years after those harms. The IJ denied asylum, but granted withholding of removal, even though the asylum and withholding claims arose out of the same factual basis. But unlike withholding, asylum is discretionary, has a lesser evidentiary burden, and provides a path to get a green card and bring one's family to the United States. Withholding, on the other hand, is mandatory if the non-citizen meets his higher evidentiary burden, but it does not provide a path to a green card or to bring one's family to the U.S. And indeed, withholding can be taken away at any time if the government shows that conditions have changed in the country such that, objectively, the non-citizen no longer has a sufficient fear. But because it's a higher burden, in nearly all cases, a non-citizen who establishes eligibility for withholding necessarily meets his evidentiary burden for asylum. So the IJ granted withholding, but denied asylum as a matter of discretion, essentially because Mr. Sathanthrasa waited 7 years to leave Sri Lanka. The IJ made clear that he did not consider family reunification concerns, as the IJ believed those concerns irrelevant. To the BIA's credit, it initially reversed and remanded the case back to the IJ, but once it came back from the IJ, the BIA eventually affirmed. The Third Circuit reversed. Here's what the IJ did wrong, according to the Third Circuit, and which I just learned. The regulation at 8 C.F.R. section 1208.16e requires that if an IJ grants withholding but denies asylum as a matter of discretion, quote, thereby effectively precluding admission of the applicant's spouse or minor children from following to join him or her, the denial of asylum shall be reconsidered, end quote. Among other things, the IJ must consider whether the non-citizen has other avenues available to reunite with his or her spouse or minor child. The Third Circuit noted that, under the regulation, reconsideration under this scenario is mandatory. And as there are, quote, extensive limitations, end quote, on the IJ's ability to deny asylum as a matter of discretion, when considering asylum under 8 CFR 1208.16e, quote, the IJ must pay special attention to the availability of reasonable alternatives for family reunification, end quote, and the hardships caused by separation. Finally, the non-citizen doesn't even have the burden during the reconsideration analysis. It's simply something that the IJ must do based on the totality of the evidence. Here, the IJ did not identify sufficiently egregious factors to warrant a denial of asylum, and expressly did not consider the hardship to the non-citizen's family of separation, or the non-existence of other alternatives for reunification. And so, the IJ and the BIA erred. How about that? Here are some observations and comments. Though the circumstance should be, quote, exceedingly rare, this case provides a non-exhaustive, well-put-together list of positive and negative factors IJs should consider when determining whether to deny asylum as a matter of discretion, under the totality of circumstances. The Third Circuit relies on case law and factors from other circuits, and it's worth a review. Here are two excellent quotes for asylum practitioners to remember. First, quote, "Violence and threats of violence must be considered cumulatively for purposes of assessing past persecution," end quote. And second, and although it did not occur in this case, quote, "An adverse credibility determination is not properly based on an absence of testimony when no one ever asked the petitioner for clarification," end quote. And lastly, as the Third Circuit notes, the Trump administration has issued a proposed regulatory rule that will likely go into effect before November that will eliminate 8 C.F.R. section 1208.16e and the reconsideration requirement, because, to paraphrase Kanye circa 2005, Donald Trump and Stephen Miller don't care about asylum seekers. And that is Sathanthrasa, the Attorney General, U.S. Next up is Deep v. Barr, published by the Fifth Circuit on July 27, 2020. This case is about motions to reopen to apply for asylum based on changed country conditions in India. Mr. Deep is from India and entered the U.S. without authorization. He did not appear for his initial immigration hearing in 2016 and was ordered removed in absentia. In 2017, he filed a motion to reopen, claiming a lack of notice of his hearing, but an IJ denied his motion. Then in 2018, he filed another motion to reopen, claiming that he was eligible for asylum based on changed country conditions in India. Now, a bit of an aside about these motions to reopen. Usually there are strict limitations on when a motion to reopen can be filed, and how many motions to reopen can be filed. But those limits don't apply when, as here, the motions to reopen are based on a lack of notice, or in order to apply for asylum based on changed country conditions. In his motion, Mr. Deep claimed that he was part of the Chamar caste in India, known as Dalit, or the Untouchables. I don't know so much about the caste system in India, but I believe this is kind of considered the lowest of the low. Mr. Deep claims that the attacks have worsened against the Chamar caste in recent years, hence the changed country conditions that warranted reopening of proceedings. The IJ denied, and then the BIA affirmed. The Fifth Circuit affirmed too, finding no error in the agency's finding that conditions, while not great, had not meaningfully changed for the Chamar caste since Mr. Deep was ordered removed in 2016. This is particularly so because, and here's the standard, the evidence showed that the increase in violence was, quote, incremental, rather than material. So Mr. Deep remains ordered removed. Here are two interesting notes. First, the fact that the Fifth Circuit considered this motion despite the fact that Mr. Deep did not appear for his initial hearing and was ordered removed in absentia is a win in and of itself, and it's worth citing, as some judges in some circuits have cast doubt on whether a non-citizen who does not appear for his initial hearing can even reopen proceedings without first establishing reasons for revoking the in absentia order. In other words, that he did not receive notice of his hearing or that exceptional circumstances prevented him from attending that hearing. Second, and just a warning, this is about to get pretty wonky. At footnote 1, the Fifth Circuit chastised government counsel from OIL for waiting until oral argument to bring to its attention the fact that the Indian Supreme Court had recently issued a favorable ruling for the Chamar caste. According to the Fifth Circuit, if OIL wanted the court to take judicial notice of this development, OIL should have alerted the Fifth Circuit of it during briefing, by submitting what's called a 28J letter. But 28J letters are reserved primarily for new legal developments, such as a new relevant Supreme Court case, that's published after briefing is completed. Foreign developments, even updates to foreign law, are really more akin to updated factual country conditions. But the Fifth Circuit still wanted a 28J letter. So to the extent any practitioner out there believes that a development in foreign country conditions is so important to a pending petition for review that the court must be made aware of it even though briefing is completed, try citing this decision for the proposition that submission of a 28J letter is appropriate. And let me know how that goes. And that is Deep v. Barr. Sticking with the Fifth Circuit, we've got Gjetani v. Barr, published on July 30th, 2020. This is a case about asylum, and according to recent Fifth Circuit appointee Judge Ho, the limits of the circuit courts in the realm of immigration. Mr. Gjetani is from Albania, and supported the Albanian Democratic Party, one of the two main political parties in Albania. During his political participation, he was threatened with death 3 to 4 times by members of the ruling party, the Albanian Socialist Party. He reported it to police, but they did nothing. Then, he and his father were attacked and beaten with belts and knives. Mr. Gjetani left Albania for the U.S. 6 months later. The IJ denied the asylum claim and the BIA affirmed. And so did the Fifth Circuit, primarily because it found that the threats and harm Mr. Gjetani suffered were not sustained and systematic enough. Or put another way, they were not, quote, regular and methodical targeting, end quote. Judge Ho pretty much says so in majority that if Mr. Gjetani had been harmed in the remaining 6 months of his time in Albania, or had been harmed again before fleeing, he'd merit asylum. But Mr. Gjetani was not. So, Mr. Gjetani will be removed. Here are 2 different approaches to asylum law, one from Judge Ho and the other from dissenting Judge Dennis. Judge Ho believes himself constrained by separation of powers issues. Quote, "Perhaps it is little surprise, then, that so many of them seek refuge in America, a country built on the idea that political disagreements are to be celebrated rather than repressed. But how our nation deals with refugees is a political decision for the political branches to make. And Congress has gone out of its way to circumscribe the role of the federal courts in this arena." End quote. So says Judge Ho. Judge Dennis, on the other hand, in dissent, would hold that under Fifth Circuit and recent Supreme Court case Guerrero-Lasprilla, the determination of whether undisputed facts, such as those at issue here, amount to persecution is a quintessential legal determination that federal courts review de novo, rather than for substantial evidence, as Judge Ho concludes. And indeed, the Attorney General said as much earlier this year, when he held that the BIA must decide de novo whether undisputed facts meet the legal definition of torture. Under that de novo standard, Judge Dennis would find that Mr. Gjetani suffered persecution. And that is Gjetani v. Barr. Next up is Marqus v. Barr, published by the Sixth Circuit on July 30th. This case is about deferral of removal under the Convention Against Torture. Mr. Marqus is a citizen of Iraq and a Chaldean Christian, who was admitted to the United States as a refugee in 2012, and later became an LPR. But in 2017 he was convicted of attempted criminal sexual conduct under Michigan Law 750.520 D1B. The IJ and the BIA held that this conviction was a particularly serious crime, making him only eligible for deferral of removal under the Convention Against Torture. The IJ and the BIA held that Mr. Marqus did not warrant deferral. Mr. Marqus argued that the agency erred in finding that he would not more likely than not be tortured in Iraq, and he was only able to bring this challenge to the Sixth Circuit due to the Supreme Court's decision this term in Nasrallah v. Barr, which now requires that appellate circuits review factual findings related to CAT claims, even for non-citizens with severe criminal convictions. And the Sixth Circuit actually didn't find error in the agency's analysis of Mr. Marqus's many claims related to his fears from Iraq. The Sixth Circuit also held that the IJ did not commit a due process violation when he excluded Mr. Marqus's country condition expert, because Mr. Marqus could not show that the exclusion resulted in prejudice. However, the court nevertheless sent the case back to the BIA, based on a finding that the BIA improperly denied Mr. Marqus's motion to remand for consideration of new country condition evidence, mainly because the BIA seems to have denied Mr. Marqus's motion with one sentence devoid of explanation. Quote, "The BIA did not even name the new evidence, let alone analyze why each piece of new evidence was either material or previously unavailable," end quote. And it appears that indeed the Department of State reports that conditions directly applicable to Mr. Marqus' fears of torture based on his Chaldean Christian faith and other factors have worsened. So the court sent the matter back. Mr. Marqus gets another shot. Here's an observation. For jurisdiction nerds out there who need to turn their factual claims into legal ones to obtain circuit review, here's a nice standard to remember. Quote, "Factual errors can qualify as a legal error when important facts have been totally overlooked and other facts have been seriously mischaracterized." End quote. Sounds good to me. And that is Marqus v. Barr. Next up is Lasu v. Barr, published by the 8th Circuit on July 31st, 2020. This is another case about deferral of removal. Mr. Lasu is a native of Egypt and a citizen of South Sudan, the newest country in the world. In 2000, Mr. Lasu entered the U.S. as a refugee. He was convicted of drug offenses and applied for asylum, withholding, and cat protection. The IJ found Mr. Lasu's convictions particularly serious crimes, but granted him deferral of removal under the cat, finding that Mr. Lasu would be tortured in South Sudan due to his membership in minority clans. But because Mr. Lasu is also a native and citizen of Egypt, the IJ ordered him removed to Egypt. And this is because, unlike asylum, withholding and cat protection only prevent a non-citizen's removal to a single specific country. If an individual obtains asylum, the non-citizen obtains permanent lawful status in the U.S. and cannot be removed to a different country. But the protection at issue here, deferral of removal under the CAT or withholding of removal, does not grant lawful status in the U.S., per se, but instead simply withholds or defers a non-citizen's removal to a specific country. Turning back to this case, DHS still appealed the grant of CAT deferral to South Sudan, possibly because it wasn't confident that Egypt would take Mr. Lasu back. The BIA agreed with DHS and reversed the CAT deferral grant. The 8th Circuit reviewed the BIA's factual findings, as it now must for CAT applications, following Nasrallah v. Barr, but denied the petition. First, the 8th Circuit found that it could not review many of Mr. Lasu's arguments because he did not assert them before the BIA until he moved the BIA for reconsideration, which would have then required that he file a separate petition for review of the motion to reconsider denial. He did not, so the 8th Circuit could not review those arguments. As to the arguments the 8th Circuit could review, it pretty much said that Mr. Lasu failed to present any evidence that South Sudan officials intended to harm him or his tribe specifically, rather than a pattern of general ethnic violence involving the at least 60 minority clans in South Sudan. So, the 8th Circuit dismissed the appeal. Judge Kelly, in dissent, disagreed, holding primarily that the evidence shows that ethnic cleansing is occurring in South Sudan, and, quote, "The BIA's concern for specificity is not warranted when the record shows that the human rights atrocities in South Sudan are widespread and occur along ethnic lines." And that is Lasu v. Barr. Finally, we've got Alzawed v. Barr, another deferral of removal case out of the 8th Circuit, published on July 31st, 2020. Mr. Alzawed is a citizen of Iraq, who was tortured by the Saddam Hussein regime from 1986 to 1989. He too entered the U.S. as a refugee in 1995, but was then convicted of 2 counts of child molestation. In removal proceedings, he was eligible only for cat deferral, but cat was denied. But he wasn't removed because we were in the middle of the war in Iraq, and in 2010, he was convicted of domestic violence and controlled substance offenses. In 2018, Mr. Alzawed moved to reopen proceedings, claiming that conditions had worsened in Iraq since 2006, such that he was now eligible for deferral under the cat. Tough claim, Mr. Alzawed. The IJ denied, but the BIA reversed, and so Mr. Alzawed got a hearing before the IJ on his new deferral claim. The IJ then denied the claim and the BIA affirmed. And so did the 8th Circuit, holding that the agency properly considered all evidence in totality, including expert testimony from both the government's expert and Mr. Alzawed's expert. DHS, it would seem, took Mr. Alzawed's case very seriously. Here's some good stuff from a factually complicated case. First, in denying the motion to reopen, the IJ believed that res judicata prevented reconsideration of certain factual findings regarding Mr. Alzawed's history in Iraq that were made in 2006. But although the BIA affirmed, it noted that the IJ was wrong about res judicata because, as proceedings had been reopened, there was no final decision in this case, which is required for res judicata to even potentially apply to IJs. And second, here's a great standard for the government actor prong under the Convention Against Torture. Quote, to show acquiescence, a petitioner must show a public official was aware of the torture by a third party and breached the legal responsibility to intervene. End quote. Works for me. And that is Alzawed v. Barr. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.